Welcome to Auditing, Audit the Audit, where we discuss the rights and wrongs of this audit.
This episode covers eluding, police dog bites, and medical care, and is brought to us by Police Activity, WKYC Channel 3, and WSYX ABC 6's channels. Be sure to check out the description below and give them the credit that they deserve. On July 4th, 2023, a state trooper in Jackson County, Ohio, attempted to pull over 23-year-old truck driver Jadarius Rose after noticing a missing mud flap on the truck. While the trooper claims that Mr. Rose made direct eye contact with him, he did not stop, and the trooper called for backup.
It was actually a motor carrier enforcement inspector for Ohio State Highway Patrol that noticed the mud flap and then contacted a trooper who then made eye contact and attempted to pull him over.
After about 20 minutes, Mr. Rose finally pulled over.
It's going to be close to the road. It's like county line. You'll see there's several minutes. Okay, I'm coming to a stop.
Get out of the truck!
You just pull back out. Okay, are you switching over to Quick County or Ross County?
He took off again. We're heading northbound, 23. He rolled the window down, looked at us, rolled it back up. We're northbound 48 miles an hour, passing Moore Road in Ross County.
I need an update for 1020 again.
After Mr. Rose saw officers with guns drawn, he drove away from the stop, and the officers began to follow and attempted to pull him over again. During the chase, Mr. Rose called 911, and the audio from the call was later shared by Cleveland news station WKYC Channel 3.
I don't know why they even pulling me over. I was about to comply with them, but they all had their guns.
Units in the pursuit. I have the guy in the semi on 911. He's complaining that you guys had his guns pulled out on him.
I don't know why they're trying to kill me. Yes, they are. Obviously, they throwing stuff on the ground, trying to explode the tires, and they feel like they're trying to kill me, and I'm not even.
Okay, sir, you need to comply with them. You
got pulled over yet.
okay, because they're in pursuit of you. You need to pull over. You're going to get yourself in more trouble than what you're already in.
Despite the operator's suggestion that Mr. Rose pulled over, he did not stop and kept driving until the officers brought the truck to a halt using so-called stop sticks, which are spiked bars that flatten the vehicle's tires. Under Section 2921.331 of the Ohio Revised Code, which defines the offense of failure to comply with an order or signal of a police officer, quote, "No person shall operate a motor vehicle so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop." Generally, a violation of this statute is a misdemeanor of the first degree. However, the statute also states that the offense is a felony of the fourth degree, quote, "if the jury or judge finds that the offender was fleeing immediately after the commission of a felony," and a felony of the third degree if the jury or judge finds that, quote, "the operation of the motor vehicle by the offender was a proximate cause of serious physical harm to persons or property," or, now quoting again, "the operation of the motor vehicle by the offender caused a substantial risk of serious physical harm to persons or property." Now, while there's no publicly available information that suggests that Mr. Rose was fleeing after committing a felony, and no harm to any individual or property was reported, it is possible that a court could conclude that Mr. Rose created a substantial risk of serious physical harm if there is any evidence that he drove recklessly or otherwise endangered property or someone's safety. On the other hand, it was reported that Mr. Rose drove the speed limit for most of the chase, so it is also possible that a court could conclude that only a conviction for the misdemeanor offense would be appropriate.
Tell them to stop there if they got wrong.
That's a dog! Come to me! You don't want bit! On the ground, you're gonna get bit. Come to me, man!
Do not let them, don't release the dog. Do not release the dog with his hands up. Do not release the dog with his hands up. Do not release the dog with his hands up. Don't. Do not. Get the dog off of it. Get the dog off of it. Okay.
Alright, units are clearing the vehicle now.
Put your hand back. Give me your hand. Give me your hand.
After Mr. Rose exits the truck, he stands with his hands up. Canine Officer Ryan Speakman of the Circleville Police Department orders Mr. Rose to get on the ground and threatens to have his dog bite him if he does not comply, while state troopers tell Mr. Rose to come to them and repeatedly shout to Officer Speakman not to release the dog. When Mr. Rose does not get on the ground, Officer Speakman releases the dog, and Mr. Rose drops to his knees, keeping his hands in the air. Officer Speakman then orders the dog to attack, and the dog bites Mr. Rose and appears to hold its grip for more than 30 seconds. Although the Circleville Police Department has not made its policies publicly available, CNN was able to review the department's policy manual for the use of police canines and reported that a canine may be used to apprehend a suspect, quote, if the canine handler reasonably believes that the individual has committed, is committing, or is threatening to commit any serious offense. CNN also stated that the policy manual authorizes such a use of a canine if the handler has a, quote, reasonable belief the suspect poses an imminent threat of violence or serious harm, or, now quoting again, if the suspect is physically resisting or threatening to resist arrest, and the use of a canine reasonably appears to be necessary to overcome such resistance. Based on these sections, it seems likely that Officer Speakman's actions were a violation of department policy, although it is possible I could reach a different conclusion if I were to review the full policy manual. In addition to potentially violating Circleville PD policy, Officer Speakman likely subjected Mr. Rose to unconstitutional excessive force by sicking the dog on him. As we have discussed many times before here on ATA, the Supreme Court held in the 1989 case of Graham versus Connor that when determining whether a police use of force was excessive, courts must consider factors, including, quote, the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. Applying these factors, the Sixth Circuit Court of Appeals, which has jurisdiction over Ohio, held in the 2013 case of Rainey versus Patton that, quote, it would be clear to a reasonable officer that employing a police dog against an unarmed suspect detained on the basis of a traffic offense who was on the ground and not attempting to flee would constitute excessive force. In reaching this conclusion, the court noted that, quote, the cases granting qualified immunity to the officer highlight the importance of facts establishing that a suspect has failed to surrender or has yet to be apprehended and has been given the opportunity to avoid an encounter with a dog before its employment. When such facts have not been present, use of a police canine has been deemed unreasonable. As Mr. Rose was clearly surrendering, it seems likely that a court would conclude that Officer Speakman's deployment of a canine was excessive force. However, the fact that an individual is raising their hands in surrender is not always sufficient for a court to conclude that a canine apprehension is unreasonable. For instance, in the 2018 case of Baxter versus Bracey, the Sixth Circuit concluded that officers were entitled to qualified immunity for using a canine to capture a suspect who had his hands in the air, noting that the suspect was hiding in an unfamiliar location after fleeing from the police and posed an unknown safety risk. The court also argued that there was no identified case law that suggested that raising hands on its own was enough to put an officer on notice that a canine apprehension was unlawful. Accordingly, it is conceivable that, given the extended pursuit that was required to stop Mr. Rose and the fact that he did not comply with Officer Speakman's orders to get on the ground, a court could conclude he posed a potential safety risk and that the use of a canine was therefore reasonable.
Get the first aid. Was that not loud enough?
You said it 3-4 multiple times.
Bro, don't touch my left arm, bro. You just let the dog bite me. Why would you touch my left arm? No, why you keep bending my arm?
We're trying to get it wrapped.
We're wrapping it up. We're not trying to hurt you.
Here. There's a pad. On it.
Bro, get off me.
I can't.
Bro, I have handcuffs on. What am I doing to you?
You could kick somebody. I don't want you to
I'm
kick
gonna kick.
anybody.
I'm not gonna kick nobody. I just got bit by a dog.
I understand that. Just
Man, you
calm
don't
down.
understand. You don't understand. Did you get bit by a
Hey,
dog?
okay.
Stop squeezing me.
Nobody, buddy. Nobody's trying to hurt you.
Shit, you just let a dog bite me.
All you had to do is come to me.
I was coming, all the guns pointing at me. How you do you expect me to respect you? You got a gun pointing at me. It's like
20 of y'all.
All you had to do was stop, brother.
I did stop. I don't feel
20
safe.
miles ago.
I did.
The officers call for emergency medical services, and while they await an ambulance, they attempt to wrap Mr. Rose's wounds using supplies from a first aid kit. In the 1983 case of Revere versus Massachusetts General Hospital, the Supreme Court held that the Due Process Clause of the 14th Amendment requires the responsible government or governmental agency to, quote, provide medical care to persons who have been injured while being apprehended by the police. Although the court also determined that because there had been no formal adjudication of guilt against the injured citizen at the time he required medical care, the Eighth Amendment's prohibition on cruel and unusual punishments, which is violated by, quote, deliberate indifference to serious medical needs of prisoners, did not apply. The court recognized that the due process rights of an individual in this situation, quote, are at least as great as the Eighth Amendment protections available to a convicted prisoner. However, it should be noted that courts have consistently held that the officers are not required to provide any sort of medical care themselves, as the court stated in the Revere case that the government's constitutional obligation was fulfilled by ensuring that the injured party was taken promptly to a hospital that provided the treatment necessary for his injury. For instance, in the 1992 case of Rich versus City of Mayfield Heights, the Sixth Circuit Court of Appeals held that officers do not have an affirmative duty to render medical assistance, and that an injured individual only had a particularized right, quote, to have medical assistance summoned immediately upon the police officers becoming aware that he was in need of immediate medical care. Consequently, in this situation, the officers clearly fulfilled their constitutional obligation by calling EMS, and a court would likely conclude that their attempts to provide further assistance to Mr. Rose exceeded the bare minimum requirements of the Due Process Clause.
What's your name, bro? You want to stand up on your feet or you want to sit on your butt? EMS is
I don't know what you're going to let me do.
I'm going to let you do it. I'm going to let you either sit or stand. As long as you ain't going to do nothing stupid.
I'm going to do something stupid.
Just have him set up, Tyler.
And you still
Let him set up.
You still let it go. Don't put pressure on me.
You have to have pressure.
Don't know. Let it be. Why are you still touching me?
Because you are under arrest.
Yeah, I have handcuffs on.
Understand.
All right, so you can stop touching me and tell me what I need to do.
James.
But I don't need your hand on me. The dog already did enough.
Probably wouldn't be bad to put one on.
See if he's got his ID with him. If not, we'll try to get it out of the truck.
Y'all not easy out there, the dog biting.
What do you mean? I gave you 3 warnings, did I not?
Man, you just pulled up. I ain't trying to hear that.
Did I not say?
The people who was
Listen to me. Did I not say final warning? You're gonna get out of the dog.
Next available rollback.
Yes or no?
It don't matter, bro.
No, you didn't comply, so you got the dog.
On the truck is deflated brake.
Where is the EMS?
They're on their way.
How long is it gonna take?
I don't know.
Well, you need to know because my arm is hurt.
They'll get here as soon as they can get here.
Why are you going in my pockets?
Get your ID.
After EMS arrived, Mr. Rose was taken to a local hospital, where he was treated and discharged. He was then taken to the Ross County Jail and later released on bond. Court records show that Mr. Rose was charged with a 4th-degree felony count of failure to comply with an order or signal of a police officer, which, as we discussed earlier in this episode, is the level of offense that would apply if the offender was fleeing immediately after the commission of a felony. However, no information regarding what this alleged felony could be has been made publicly available, and as of the date of writing this episode, the charge against Mr. Rose is still pending. Following the incident, investigations were launched into Officer Speakman's conduct, and Circleville's Civilian Police Review Board which does not have the authority to recommend officer discipline, determined that he did not violate department policy when he deployed the dog. Officer Speakman was placed on paid administrative leave while the Circleville PD conducted an internal investigation, and on July 26, 2023, Officer Speakman was terminated, not for his conduct during the encounter with Mr. Rose, but due to his actions during the inquiry. The department claimed that Officer Speakman misrepresented the fact that he had spoken with many people outside of the department about the incident, and accused Officer Speakman of violating 3 department policies: failure to disclose or misrepresenting material facts or making any false or misleading statements on any application, examination form, or other official document, report, or form, or during the course of any work-related investigation; criminal, dishonest, or disgraceful conduct that adversely affects the member's relationship with the department; and dishonest honest or dishonest actions. After his termination, Officer Speakman's union, the Ohio Patrolmen's Benevolent Association, filed a grievance, arguing that he had been fired without just cause, the outcome of which has not been announced as of the date of writing this episode. Prominent civil rights lawyer Benjamin Crump, who represented the families of Trayvon Martin, George Floyd, Ahmaud Arbery, Breonna Taylor, and Keenan Anderson, has announced that he will represent Mr. Rose, along with Ohio attorney Kenneth Abarno. The attorneys released a statement arguing that, quote, "The bottom line is that Speakman used force on Jadarius while he was complying. In our opinion, that force was excessive. The excessive force Speakman used was not a baton or taser like we often see in these incidents. It was a live animal that repeatedly sunk its teeth into an already terrified Jadarius, conjuring disturbing images from the past." As of the date of writing this episode, Mr. Rose has not yet filed a lawsuit, but it seems likely that he will be pursuing legal action with the help of his attorneys. Overall, Officer Speakman gets an F for ordering a canine to bite an unarmed and surrendering citizen, resorting to the use of likely excessive force to gain compliance with an order from a non-violent individual, and ignoring instructions from the police agency in charge of the apprehension. Throughout the encounter, Officer Speakman's actions demonstrated a total lack of empathy for Mr. Rose and the pain he caused him, and he seemed completely oblivious to the fact that his actions were potentially unconstitutional. In fact, Officer Speakman's body camera captured a conversation with a colleague where he expressed his bewilderment as to why the state troopers were upset with him.
I don't know why they seem like...
I don't know.
He didn't comply. I gave him 3 commands. I told him, final warning. If you don't get on the ground, you're going to get the dog. I don't know why they seem mad at me for it. He wasn't complying. I mean, am I wrong?
These statements, combined with his actions during the encounter, reveal an overly authoritarian and violent attitude that I find more than disturbing. And even though he was not terminated for his actions in deploying the dog, I applaud his removal from the Circleville police force. Mr. Rose gets a C. Because although Officer Speakman's use of force against him was clearly unwarranted, he failed to pull over for a traffic stop for nearly 20 minutes, then drove off again and did not stop until officers rendered the vehicle immobile. While it is unclear why Mr. Rose did not pull over his vehicle originally, I can certainly empathize with his apprehension about getting out of the vehicle when multiple officers had firearms pointed at him, although it is important to recognize that the law would still require him to comply with the orders despite his fears. That being said, although Mr. Rose obviously would have been better off if he had simply pulled over when the first trooper tried to stop him, he in no way deserved to be bitten by a dog or suffer the excruciating pain he was subjected to. Mr. Rose was clearly attempting to surrender while navigating the officer's conflicting commands when Officer Speakman chose to deploy the canine, and the responsibility for that decision lies entirely with Officer Speakman. This encounter demonstrates the real and justifiable fear that many individuals feel when interacting with the police, and the substantial rift between law enforcement and minority citizens that currently exists in America.
Overall, Audit the Audit gets a C- for having a decent understanding of what happened, but not doing the necessary work to get the facts straight.